Now, where are we? And thank you.
We are going to do Unit 5.
Okay.
We're going to start with our focus areas.
Okay. You start now or you started already?
No, I'm only going to start now.
Oh, I'm lucky.
Yes.
Thank you.
Pleasure.
Can someone please mute my mic?
And switch off your camera.
Rhonda, your camera and your mic is okay. You've got the mic now, but you are shown.
Yeah, your camera is off now.
Okay. Let's start. I don't want to keep you guys too late. I'm not sure how many of you have a chance to look at the focus areas that I put on the group. Some of you are still new on the group, so I'm not sure if that shows under your files of the group. But if you've got a pen and paper ready, we can start. Yes, Tobile.
Greetings, ma'am.
Hi.
Just a quick question. Will this session be recorded?
Yes, it is being recorded.
Thank you very much.
Okay. I think we should start. Yeah. So the focus areas, they are 8 of them. Okay. So I'm going to go through them very slowly. And if you need me to stop, just tell me to stop and I will wait for you. Okay. So if you're ready, we should be able to do the following if you've done Unit 5. Okay. We must know the main divisions of law, the divisions of these divisions. So the main divisions and then the divisions underneath that. Okay. As well as the subdivision of that. So it's going to be your main divisions, divisions under that, and then the subdivisions of that. Okay, so it's like 3 steps. All right. Then you must also know the other areas of law. That is one of the main things you must know. So it's the main division of law, then the divisions under these main divisions, and then the subdivisions of those divisions. And then further, the other subdivisions of that. Okay. And then the other areas of law. All right. So it's a mouthful. Their note says, if it sounds like a tongue twister, you should then refer to the diagram on page 68 of the unit. Then it shows you exactly what I mean. So if you have your study guide with you, then it is on page 68. Yes, Jabulani?
Ma'am, can you please resend the focus points before?
Okay. Your mic is on. Thank you. Okay. So I'll Halisa, you've got a question?
Oh, no, ma'am, I was gonna say someone's mic is on, so I couldn't hear what you were saying.
Yeah, I don't want to mute you all because I want us to interact. So please just keep your mic off when you're not speaking. Okay. So yeah, let's go on with the focus areas. I will send them as soon as I get off here. So I'm struggling getting my WhatsApp to work on the laptop, and I think it's going to be distracting trying to do two things. All right. We must be able to recognize the difference between the main divisions of our law, which is public and private law. So we must know the definition of each and what differences are there between them. Public law is concerned with public interests, the interest of the community, while private law deals with individual interests. Okay. The public law has 5 divisions. Okay. The law procedure under the public law has 3 subdivisions. We will get to that now. So if you look at page 68, then you will see that public law has international law, constitutional law, administrative law, criminal law, and law of procedure, which under law of procedure has civil procedure, criminal procedure, and law of evidence. Okay, that is your public law. Now the private law has 4, namely law of persons, family law, law of personality, law of patrimony. A, law of property or things, that is testative succession, intestate succession. Then C, law of obligations. Firstly, law of contract, law of dialect, and enrichment. Okay, so then we have other areas of our law, which are mercantile law, labor law, conflict of laws, and legal philosophy. Right, so I broke it all up for you. But it is important that we know this diagram and the differences so that we can identify which is private and which is public law. All right. Okay, yes, someone, sorry. You will also know that the divisions of the private law appear to be more complex than the divisions under the public law. Okay. Private law has 4 divisions, which patrimony has 3 subdivisions. Okay. Then law of obligations, also a subdivision under the law of patrimony, has 3 other subdivisions. So private law has 4 divisions, law of patrimony has 3 divisions, and law of succession has a further 2 subdivisions. Okay. We also have other areas of law which do not strictly belong to private or public law. It may fall under both. Okay. Activity 5.1. Why is that important? Okay. Okay, 5.1 gives you practical that you can see if you know what, so it's a practical application to real life situations. Ensure that you understand these activities and their feedback. So 1.5.2 is there's on page 74 and 75. And then the feedback is until, you just double check, until 81. So from page 74 all the way to 81 is the activities that we must go through, and that'll help us to understand the practical application of these divisions that we have. Is there anyone with a question? Guys, is there a question?
Not from my side.
Is there anyone else with a question? Are you okay for now, or can we go on, or can we start going through the textbook or the study guide? Actually, it's not a textbook anymore. So where do you guys, let's go to what is private and what is public law. Okay, so the two main divisions we said is public law, where public interest is concerned, the interest of the community. Public law therefore deals with the relationship between the state and the subject of the state, the citizen. If someone commits a crime, this act goes against the interest of the community, so it becomes public law. Private law deals with the relationship between individuals, so marriage, things like that. So yeah, it is both public and private law may be applicable to a set of facts. If the same act harms the interest not only of the community, but also a private person, the act becomes concerned with both public and private. Okay. Yes. Okay. So what is your understanding of public law? If you need to explain it to someone in your own words, how will you explain it? Lucas, you can ask or answer me. Lucas? I see your hands up. Rhonda, you have a question?
No. Hi, guys. So you asked about the public law, ne?
Yes.
When you say public law, guys, like we mean to say the relationship between the states and the people, with us people in general, like what the state says we must do and what we must do according to the law. Governed by the state. Thank you.
Azande. Hi. Azande, your hand's up. Do you have a question for us?
You asked for us to explain public law.
Yes.
Okay, ma'am. Public law governs the relationships between the state and individual or other entities, including constitutional law, administrative law, and criminal law.
Yes, you are correct. Got a good understanding of it. Okay, so if we know that is public, how will you explain what is private law? What is private law, guys? I can't answer using my... Yes, you can ask.
Ma'am, can I answer?
Yes, you may answer.
It deals with the relationship between an individual and an individual. For example, if A steals B's property, A prosecuted plus the punishment by the state, which is a public law action, and then B, it claims damages, compensation from A, which is a private action.
Yes, good. Okay, so I told you guys about subdivisions or the main divisions of public law. Those are public international law, constitutional law, administrative law, and criminal law, as well as law of procedure. Okay, what do you understand under the term public international law?
Ma'am, can I answer?
Yes, you may answer.
Public international law is the relation between states. For example, law of war and peace, law of international organizations, and law of international what do you call this? Treaties.
Okay, yes. Okay, anyone else with the answer? Guys, we need to participate to
Yes, ma'am,
understand.
can
Yes,
I
you
answer?
may. Yes, you may.
Public relationship law, ma'am.
Yes.
Governs relations between states or countries, covering creative diplomacy and international agreements.
Yes.
Thank
Okay.
you.
It's a pleasure. Zooks, I see you've got a hand up. Zooks. Zooks, are you having trouble with your mic? I see your hands up. There's another hand. Is that an old hand or do you want to ask a question? Okay. So what is constitutional law? Yes, Palisa? Please put your mic off if you're not
Um,
asking a question.
Constitutional law is the supreme or fundamental laws of a nation that defines the structure and limitations of government.
Good.
Mhm.
Hey, Choma, your mic is on. Yeah, that was a very good explanation. Let's go to administrative law. What does that entail? What does that law entail? Okay, so an administrative law controls the administration of the state in general. The way in which state bodies, state departments and numerous boards, as well as ministers, exercise their powers. Okay. Criminal law. Ooh, what's criminal law? What would that entail? Is there anyone who wants to take a guess?
It's around how the state protect the citizens or stand for the citizens in events of crimes.
Yes, it is. Anyone want to add to it? Yes, Azande?
Yes, ma'am. Hello, everyone. I'm explaining criminal law.
Yes.
Hey, ma'am. I think criminal laws deals with actions considered crimes against society, prescribing punishments for offenders like thefts, assault, or murder.
Yes, you guys will give good answers in your exams. Okay. Palisa? Good, Azande. Palisa, do you have a question?
No, I was just gonna add.
Yes, you may add as much as you want.
Okay, so criminal law is the body of law that defines offenses against the state or individual, regulating the investigation and punishment of offenders.
Yes, you all agree with her? Okay. Law of procedure. Law of criminal. Okay. Criminal law's primary goal is to punish. Yes. Unlawful acts. Yes. What is law of procedures? Okay, yes, still on the criminal law is unlawful conducts that threatens public safety and welfare and maintain law and order. Good. So what is law of procedure? Nolutando?
I think law of procedure refers to rules governing how cases are processed in courts. Am I correct?
Yes. So which one of those do you want to address? There is subdivisions, law of civil procedure, law of criminal procedure, and then law of evidence. Azande, yes. I'm getting to you guys.
Hello, ma'am.
Yes,
Hello.
I hear you.
Explaining law procedures.
Yes.
Uh,
Nolutando.
ma'am, am I correct or not?
We could not hear you at all. Azande, try again.
Can you hear me now?
Yes.
And we are law procedures.
I think you're muting yourself every time you speak.
Can you hear me now?
Yes.
Law procedures. Rules and steps followed in court or legal processes like filing a case, presenting evidence, or appealing a decision.
Yes. Okay. Palisa, Giuliani, I'm getting to you now. Palisa?
I'm sorry, ma'am. It's an old hand. I'll take it
Okay.
down now.
Jabulani?
Yes, ma'am. I just wanted to add on what you said. As far as I'm also concerned, I know that law of criminal procedure is divided into 3 divisions. But since we are talking about the criminal procedure right now, I would say this is part of the adjective law, which declares how cases of the alleged law offenders should be prosecuted.
Yes. Good. Okay. Ongani, do you have something to add or something? Another question, or what can we do to help you?
I do have an addition here on the law of procedure. We can say, from my understanding, that it forms under formal justice, whereby it outlines how crimes of a similar nature are processed, including the procedure that need to be followed to take that case to a court, or to institute a claim, or to evaluate and present admissible evidence in the court. That's my understanding.
Okay. I see there's another hand. Anyone want to chip in? Anandi? Anandi. Ooh, I'm pronouncing.
Since the criminal procedures
Okay.
I thought there was someone.
Anandi?
Now you can continue. I'll come after you.
Okay, Jabulani.
Can I continue?
Hello.
Yes. Bongani, just put your mouth. Jabulani, you can speak.
With the procedural of the.
Okay. Jabulani, you're breaking up. I think there's an issue with your network. You keep cutting out. Okay, Anandi.
Okay, ma'am. It's undone. Okay. And ma'am,
sorry, I am very sorry.
No, it's no problem, ma'am. According to me, law of procedure does not create rights or obligations. Instead, it provides the steps, methods, and formalities for applying the law. And the steps that it provides are in the diagram, the subdivisions: civil procedure, criminal procedure, and law of evidence. Since yes, this laws consists of the rules and processes that explain how legal rights and duties are enforced in court.
Yes, very good. Anyone else with a question or something they want to add to that? Yes, Jabulani, are you now with us?
Yes, I'm back. Am I audible?
Yes.
Yes. Ma'am, I just wanted to confirm. Since that now we are, we are sure that the law of criminal procedure deals with the proceedings of how the cases of the alleged law offenders are conducted. I want to know which law is concerned with the proceedings of the investigations.
Isn't that law of evidence?
I guess it might. Doesn't fall under the criminal procedure.
Concerned with how the accused. That's a good question. Because law of criminal procedure is how accused are prosecuted and tried. And law of evidence says how evidence should be presented.
Yes, because it's now presented in court, if I'm understanding that correct.
Yes.
At this stage.
Yes.
So, meaning at this stage we already have the evidence that is to be presented at court. What about before the evidence being presented in court? Which law deals with that proceedings of the evidence finding or investigation, for that matter?
I'm just checking something.
Okay, no problem.
Method how private law disputes are brought to court. Anyone with the answer? Because I'm a little stumped. I'm jumping between two things here, and I'm not sure if I'm correct. Is there anyone who wants to answer that?
Yeah. I'm in line to try to dissect this legal quagmire.
Okay.
Here, the criminal procedure is based on the premise that the accused person is innocent until proven guilty. Then the process of proving of unproving the innocence requires that both parties in the criminal matter be heard in court through testifying and presentation of witnesses and evidence. So criminal procedure requires evidence to prove the assumption that the accused person is innocent or is guilty. Because on the premise of criminal law, every accused person is innocent until proven guilty beyond reasonable doubt. So the presentation of evidence, its admissibility, the witnesses, and the testimony forms that part of beyond reasonable doubt presentation that the accused person is not innocent, is actually guilty as charged.
Okay, I think what he wants to know from us is what is the law involved in the gathering of evidence before it goes to court? Which law does it fall under?
I'll stand by my understanding that is law of procedure, including the procedure. Let's assume that the witness to, or the victim is a minor. There is a procedure to get an interview of a minor, not looking into the interview as evidence, but the procedure of acquiring that interview falls under the law of procedure. Either it's a criminal procedure or a civil procedure. I think it is guided by civil procedure. Oh, sorry, by law of procedure, be it a civil matter or a criminal matter. The process of acquiring that evidence before it is presented in court, the process of acquiring the evidence should fall within the law of procedure.
Oh, hi guys. I also wanted to say the same thing. There's a format or there's a way, rules that you must follow as an investigator, what you must do and what you mustn't do. I think it also comes back to the law of procedure. Thank you.
Guys, I'm not sure if my question is answered to the fullest, because what we said previously when we started, we said that law of procedure is divided into 3 divisions. So if you say it falls under law of procedure, which procedure are you pertinently referring to?
Oh, okay. To be precise, brother, a law of evidence, I think it goes there. Like how you gather evidence, the pros and what you must do and what you must do gathering the evidence. So it should be the law of evidence. Thank you.
Anyone else want to take? Yes?
I thought it was our agreement that law of evidence, it deals with the evidence that is already prescribed at court, that is already submitted at court. I don't know if I'm getting lost.
Hello.
Greetings. I this law of procedure, because law of evidence, already the evidence is there.
Okay, I understand what Jabulani wants to say. It is, if we say it's law of evidence, it is after the fact when we are in court and we are giving evidence. But what he wants to know is which, if it's under law of procedure, which is it? Law of civil procedures, law of criminal procedures, or law of evidence? But law of evidence is only what is presented before the court.
Hello, ma'am.
Exactly. I agree with you, ma'am.
Oh, I also see the light there. Thank you. So it should be the law of criminal procedure. Oh, wow.
Hello.
Yeah.
I still stand with my reasoning that if the matter is a civil matter, it follows a prescribed procedure in dealing out with that, in dealing out with the civil matter presented. If it's a criminal law case, there are prescribed procedures that need to be followed, because evidence in maybe we can say in criminal procedure can mean a lot of things, be it a photograph, be it anything that is used to prove beyond reasonable doubt that the person who is assumed before the law that is innocent, that this person is actually guilty, is charged. So if the matter is a civil matter, with the whatever evidence is gathered to prove that the dispute between these two parties is under civil procedure. If it's a criminal case that requires any form of understanding, then the criminal procedure gives the guidelines as to what needs to be done and what cannot be done. I gave an example that let's assume that the witness, the key witness, is a minor, a rape victim. There is a law that governs how you collect this testimony of the victim in the case that is a minor. Be it that evidence is admissible or not is another legal question, either that evidence will be admissible or not.
Okay. Some says it's both, depending on the case brought forward. So it's either criminal or law of civil procedures. Is that what you guys are saying? So it depends on what case is brought forward, which evidence needs to be presented in law of evidence.
Can I please read here, guys? Can
yes.
I please?
Page, what are you on?
On law of civil procedure, the last sentence.
Yes.
What the jurisdiction of each court is, the fact that each party must have an opportunity to be heard and so on. So the time when you want to hear from someone, from the accused, so it's how you are gathering evidence, isn't it? So it should be the law of criminal procedure. I stand to be corrected also. Of civil procedure.
Okay, someone opened a can of worms. Yes, Bongani, do you want to counter that?
Yeah, she raised a very valid point that of the jurisdiction of the court. That's a procedure that needs to be accounted in the carrying out of within the procedure. If it's a case that falls within the magistrate court's jurisdiction, that's what the procedure governs. If it's a high court, if the high court has the jurisdiction on the matter, it is prescribed on that procedure, be it a civil matter or a criminal matter. So let's forget about the evidence, because evidence proves that the accused person is guilty, or it proves negligence, it proves delict, it proves the validity of the contract, it proves unlawful enrichment. So evidence comes to prove a point, but the procedure is the one that will determine what type of evidence is needed to prove or to counter an argument.
Does that answer your question better, Jabulani?
Yeah, to some certainty it does, ma'am. Thank you.
All right. Rhonda, do you have a question for us? Okay, your hand's gone. Yes, do you have a question? Okay. Now we look at the divisions of private law. You get law of persons, which is concerned with the persons as subjects of law. Okay, so the legal subjects, beginning, status, and end, only in the eyes of the law. Remember, it's only in the eyes of the law. Okay, then you get family law, which is concerned with the legal relationship between spouses, parent and child, and guardian, or child and guardian.
I just took a little bit. Not all of it.
Okay, it covers marriage.
It's still full. Okay, well, now we cut the marat. Like it's here.
Brianna, you have a question? Okay, goodbye. Covers marriage, its consequences and relationship within family, like in the parent and child. Then we get law of personality. This is concerned with personality rights. We all have them, which is the rights to our body, good name, reputation, and dignity. if infringed claim of money as satisfaction. So if someone calls your names and bad mouths your name and your business name, and you decide to sue them for what do we call the word?
Defamation.
Yes, defamation of character. Then it is a law of personality. Okay. Now the law of patrimony is concerned with the relationships between persons and their means. Means whatever person that can be given value in money. Okay, so those law of patrimony is divided into 3 subsections. Law of things, it's movable things like cars, books. And then immovable objects are things that cannot be moved and are fixed, so like land or a house. And then ownership is the most comprehensive right in property. That is a real right. Okay. Law of succession. Who inherits the property of? Okay, so if someone dies and they leave a will, a valid will, the testate succession is carried out as stated in the will. Okay, if there's no or invalid will, property is divided in terms of the rules of interstate succession. Okay, so what are those two? What is testate succession? Who can help me?
Succession is somebody that has a will.
Yes? Hilani? Bongani, I'm here. Bongani, yes.
Testate succession is a testimony on how to distribute the estate of the deceased. It is a testimony how to distribute the estate of the deceased.
Yes, that is correct. Now, what is in-state succession? What would that be?
Not in state, ma'am. It is interstate.
Yeah, sorry, I mispronounced that one very badly. Sorry. Yes, Bongani.
Is the distribution of the deceased estate amongst his or her surviving dependents.
Yes. Now I learned something new too. Okay, so we know what happens with testate succession and interstate. The way these words. Sedibana, I can't. Sharon, please tell me what is the first name. I'm like butchering you guys' names. You must excuse me. Sharon, I see your hands up. Okay. Is there anyone who can? Yes.
I wanted to ask the guy that said it is a testimony. I don't know what he said going forward. Is there a difference between a testimony and a will? Because I think a testimony is a written evidence and a will is a written letter. Let me see. There are two different things according to me. I stand to be corrected.
The testament of how to distribute the estate of the deceased, because the estate is coming from testament. It is the testament, not a testimony. A testament is a written account of how the deceased estate will be distributed. It is a testament.
Okay, do you understand now? Papelo, I'm coming to you, Jabulani. Papelo, yeah, sorry if I pronounce your name incorrect. Papelo? Okay,
I'm sorry, ma'am, am I audible?
Yes, you are.
Yeah, I just wanted to add on the interstate sanction. I felt like Mr. Bongani wasn't really explaining it to the basic. So like I maybe thought that maybe people might find it hard. So I have like a basic explanation for it. So with interstate sanctions, it occurs when a person dies without leaving a valid will. And with the first one, it happens when a person dies, but then they leave a will so that the rest of the family can know which goes to which to contribute the whatever that the person had left. But with an interstate sanction, it occurs when the person died without leaving a will, and then it leaves the work to the state to distribute according to the Interstate Sanction Act. Thank you.
Good.
Perfect.
Jabulani, I see your hands up.
Yes, ma'am. Thank you so much. I wanna take a step back, but I don't wanna interfere with the lesson already. Can I just ask Mr. Bongani and the lady who was helping her to answer my question on under civil law to just pin their finger on their notes there, because I still have a question, but I can ask it later when we are done.
Okay, we'll give you a chance about that. Okay.
Thank you.
Palisa?
Oh, I wanted to ask more about interstate succession, but I think I've already been answered. Yeah, so no need.
Okay. Fumani, I hope I pronounced that correct.
Good evening. I heard one speaker saying that a will is for the living dependents. I just wanted to correct that it's not only for the living dependent. It's a will. It's not confined to whether the people were dependent or not. It's what your wishes are, a testimony that you give, your final will and testimony. Thank you.
Yes, that is. Yeah, that is. It's not depending on who your dependents were. If you want to leave your whole estate to a non-profit organization, you are allowed to. If you don't have any children or siblings or a wife or husband, and you donate all the money you have to charity, that is, and it's written in your will, there is no dependents who can make claim on your will or your estate in that matter. Okay. I think people are confusing a dependent and okay, there's a, just see who's there. A beneficiary. Okay, I understand. Yeah, I think they are confusing dependents and beneficiaries. Okay. Can we go on to the next one? Fabelo, do you still have a question? Or is it an old hand?
It's an old hand, ma'am. Sorry.
That's fine. Okay. Law of obligation. That is a legal relationship between two and more parties. Okay. One have the right to performance and the other has the duty to perform. Obligations can arise by an agreement, a dialect, or justified enrichment. So law of obligation is divided into three subdivisions. Law of contract, law of dialect, and unjustified enrichment. Let's see, what is law of contract? Sorry, law of contract is what? Who can help me with that? Okay, I'm going to give you an example. A buyer has the right to deliver or claim for the thing bought. So if, yes, Azande. Azande, your hands up.
Yes, ma'am. Am I audible?
Yes.
Explanations of law of contract. Yes. Yes.
Yes.
It's legally binding agreement between parties involving offer, acceptance, and consideration like payment or promise.
Exactly. So it is the right for a buyer, it's the right to deliver, and the seller is the duty to deliver. So if you have a car, you bought a car, you have to claim it, but the seller has the duty to deliver. All right. So if you buy a car, you are legally bound to, by law of contract, to pay for that car, and the seller has the duty to deliver on your payment. Okay. Does that make sense to you? Okay, hopefully it does. Oh, I'm going to butcher this name. Zamawisle. I just butchered it most likely. Mali?
I want to ask, can you briefly explain, maybe make an example about the law of obligations?
Okay. So, law of obligations is a legal relationship between two or more parties. So, let's use the car. You have the you're going to go buy your first car. You put down a deposit, and your dealer for the car he has the right to deliver to you, but if you do not pay him for the car, he can take the car back, because that you broke the law of contract, because you didn't pay up to what he wants to every month. You didn't pay that. Okay, so what happens is there's a legal relationship. That's why we sign contracts. Verbal contracts is not a thing really anymore because of so many cases against each other because it was said and not written down. So you and your car dealer has an agreement, a written contract, and you have an obligation to pay for the car, and he has as a duty to give you the car once paid. Okay, does that make sense to you?
Yes, thank you.
Pleasure. Okay, anyone else with a question? Bongani?
It will be an addition on the law of contracts. It regulates the relationship, the obligation between two parties in avoidance of error or mistake. 2, fraud or dollars. 3, and duress or metus. So the contract, the binding contract avoids these mistakes, because if the contract entered into is found to be defective of these categories, it is regarded as an invalid contract. So a law of contract regulates the validity of a relationship between two parties to avoid mistakes, fraud, and duress. You cannot sign a contract under duress. You cannot sign a mistaken contract, and you cannot sign a contract that is liable to a fraud.
Okay, does anyone disagree or agree with him? Are you all happy with that explanation?
There was too much English there.
You need it to be in another language. Unfortunately, I can't translate. I'll be terrible. I'm even having trouble with the names. What about translating? Bongani?
Okay, we can say the law of contract regulates a valid consensus between parties in avoidance of any mistakes, fraud, or duress. Mistake, fraud, or duress. I think it will be plain like this.
Okay. Anyone have a question? Okay. So that was law of contract and law of obligation. I didn't get the question. Okay, just what is law of dialect? Okay, we've got a question here. Lucas didn't get the question. He's a little confused. Can someone just... Okay, I'll get to your question now. I'm Moroba. I think I've mispronounced, but you've got a question or an answer or...
Oh, hi, ma'am. Yes, I do have an answer for the question that you just asked right now.
Okay.
So the meaning of it is an unlawful act by one party that causes damage to another party.
Yes. Anyone want to add to that?
Can I add?
Yes.
Can I go first?
Can I go first? If you don't mind.
Okay, no problem.
Since she explained that law of delict is an unlawful act by another party, to me it goes hand in hand with civil law. It actually has a relationship with civil law since it deals with disputes between individuals or parties, maybe organizations, and organizations that are seeking for compensation or resolutions. And this law has to make sure that those parties that are seeking for compensation has to be compensated at the end.
Okay. Anyone else? Okay. Lucas says. Okay, Lucas disappeared again. He was talking about Okay. Azande, you have a question, or Pelisa? Who wants to go
Hi, ma'am.
first?
I have an explanation.
Okay.
It's a wrongful act or omission causing harm with fault and accusation allowing victim to claim damages. It's a law of delete.
Yes, I do agree. Melissa, do you have another opinion?
Not really, but I can just say it anyways.
Yes, say it.
A law of delict is a branch of civil law governing situations whereby one party, which is the wrongdoer, causes harm to another party, and then creating an obligation to pay for compensation.
Yes. Okay. Lucas says the law of dialect, we can articulate the law of dialect by looking at the case of Edward Nathan Sonneberg and Mrs. Hardwin. Okay, if you want to check that out. Bongani, you've got a question or an answer?
It was an addition that a law of delict is a law of negligence that causes harm to the other person, and this harm is the one that violates the personality right of an entity or of the subject. The law of delict focuses on the element of negligence that is rated or that is experienced by the other party to an extent of having a certain violation on his personality integrity.
Rhonda?
Hi guys. I'm so sorry. I have to take you back a little. There are two speakers who just mentioned the word civil law. Guys, can someone just please explain for me civil law? Is it different from civil procedure, and how does it link to law of delict? Please, I'm just confused here.
Does anyone want to help her with that? Anyone who has an explanation for her?
For the sake of progress, I would suggest that we save that question for later because I think it's more related to the law of procedure.
Okay. We'll come back to your question. We will definitely.
No, guys.
Before we leave, we will answer everyone's extra questions, okay?
Okay, don't forget, please. Thank you.
I won't forget.
Thank you.
Pleasure. Okay, so the last one. Is there someone who wants to answer a question? Andani?
Yes, ma'am. Am I
Yes,
audible?
ma'am.
Yes.
I wanted to take you back to the is it tester section and I can't pronounce it well.
Yes.
It's a scenario question type alike.
Okay.
So let's take if I am rich, ma'am, and then I don't have children or relatives. And then I write a will that my things should be given to a certain orphanage. So it will fall under the first one, which I can't pronounce, I don't want to lie. And then if I'm rich and then I don't have a will, how will the state handle it? Because I think it falls under the second one. Will the state try to find another relative of mine, or they will just divide my things all over the states to help?
Okay, they normally divide it. Okay, I'm getting your answer. Brianna's typing here. They normally divide your property to... Okay. Brianna, can you answer her, or should I wait for you to finish typing? Brianna has a good answer. She had a very good answer, and now she's gone. I think what happens if you have a will, the testate succession, I think the will tell you it's going to that orphanage, finish and clock. But I think when it is not a valid will and they've exercised every possible route to find a relative that might be able to inherit, I think then it will be dispersed throughout other people. It might be dissolved completely into the to the state, unless otherwise, if they find someone, then fine, then you can it goes automatically to your relative. But I think it's been, if they can't find anyone, I think it just dissolves into I stand corrected if I say it dissolves into the state. Yeah, so I'm standing under correction there. Does anyone else have an idea?
I'm also standing under correction because that's exactly what I was thinking. I thought maybe I'd be wrong or something. So if anyone has the correct answer, can you please make me understand, because it's kind of confusing.
It is confusing. I do agree with you.
I will try to explain from the perspective that I understood it. I think interstate succession is better explained from the presumption of death. When the estater, sorry, I cannot use that. When the principal is assumed to have died, maybe due to long absence, without leaving a will. So the estate is assumed by the state under the estate act. I'm not sure which act is that. Then when the beneficiaries have to make a declaration that the principal has deceased and they need a share of the estate, and there's certain deposits that they're supposed to make with the deeds office. So as an assurance that in the event that the person comes again, they will have then to pay it back. So why I say this is the better explanation, because it gives a broader understanding on how this succession or without a will happens. It tries to cover all the dependents or the beneficiaries. It tries to cover all the beneficiaries as assumed by the law that they were supposed to inherit in the event that the a missing person is truly deceased. That's where I took it from the law of persons. And presumption of death, where even the institution of divorce, a dissolution of marriage, it seems as if, according to my understanding, a little bit explained, like for the interstate succession, whereby it is not whereby the person is assumed to have passed and the person didn't leave a will, either by choice or by circumstances.
I've been raising my hand. Can I be recognized, please?
You can speak.
Okay, thank you. I want to correct something here, which was said by Mr. Bongani. And in, Mr. Bongani, he can say that legal delicт focuses in negligence. Because of, according to me, even if you can check, negligence, it is a failure to act with the care that a reasonable person would have exercised in the same circumstance. So the way I see negligence, it goes along with defamation and assault. It's an example of the law of delicт. And then in that case, I would like to put negligence in example of law of delict, whereby maybe a driver runs a red light and causes an accident, injuring another person. So there we can find a conduct and a fault and a harm, whereby the conduct is a reckless driving and a fault will be a negligence as an example of law of delict. Therefore, the harm there is physical injury and property damage. So Mr. Bongani there has made the wrong statement that the legal law of delict focuses in negligence. Negligence is an example. There are more other examples go along with negligence.
Yeah. Yeah, negligence is just an example of law of dialect. Bongani, do you want to say something?
Yeah, I do want to say something. I'm not trying to defend myself, but this is the way I understood it. That's why I assumed that in negligence will cover quite a number of delictual acts, because there has to be a conduct, there has to be a wrongfulness, there has to be a fault, there have to be a causation, there have to be a damage, there have to be these are delictual remedies. And so my understanding is that any form of negligence that affects the other person is liable to a delictual claim. Be it the example that is given by the respondent, that someone overruns a red light and injures someone at the end of it. That's a form of negligence within the understanding, because the law of delict needs to prove that this person acted negligent in his conduct that had led to the causation of harm to the other person. If there are many examples that I can give to prove that the act has to be negligent and causing harm to the other person. Not necessarily that the key term is negligence that I meant to use as a definition of law of derelict, but the act of the person shows an element of negligence, not that the person is insane to conduct his affairs normally, but within the realms of being normal, he acted with an element of negligence. We had a very popular case here about the what was this where disabled people were taken from life as a demand. It was under negligence, the life as a demand case, because the main argument was that the Department of Health acted negligently, not necessarily that they were negligent, but they acted negligently. The case of life as a demand.
Oh, Bongani. Bongani.
Yes, I can hear you.
So you're saying negligence isn't, so after negligence there comes compensation, is it?
Those will be the remedies. How do you rectify your negligence? Will you do the remedies? That falls under delictual remedies.
I think you are right. I also get your point.
Yes, you can call it compensation because the injured person can sue for medical costs and damages.
Okay. Thank you.
Yes, I am agreeing on that. Yes, a Nombela. Abelo, you've got your hand up. I think that's an old hand, so if it's a question, just thumbs up me, because I can see your hand, but I think it's an old hand. I don't want to be rude and skip you.
I'm sorry, ma'am. If I have a question, I'll just open my mic instantly. I don't know what's going on. I'm having technical issues. I cannot lower my hand.
Okay, no, it's fine. I'm just checking.
Thank you.
It's a pleasure. What is unjustified enrichment? Unjustified enrichment. What do you think is that? I've got a definition of it. One estate may not increase at the expense of another without a legally valid ground justifying enrichment. Sharon?
I think it is when someone is getting something for nothing. Like if you pay me 100 rand by mistake, then I keep it, even though when I know it is not mine.
Yes, and just to add on Nzani's answer, unjustified enrichment also ensures that no one can profit unjustly, as she said, from the person who suffered a loss and then you claim it.
Okay. Azande?
Can you repeat your question, ma'am?
I want to know what is unjustified enrichment.
Unjustified enrichment.
Yes.
Okay, ma'am, we'll get back to you.
Okay. Is there anyone else who wants to take a turn? In what way, in accordance with our law, what is unjustified enrichment? Okay, Lucas says it's a principle that aims at ensuring that one doesn't benefit unsurely Okay, Azande. Azande, do you have a question?
Yes, ma'am. I want to ask you what is the unjustified money enrichment? It's unjustified gain at someone's expenses, obligation to return benefits.
Okay. Okay, I'm getting back to Lucas. Lucas says it is principle that aim at ensuring that one doesn't benefit unsurely and unfairly. Nolutando, do you have a question or a statement you want to add?
There is a statement I want to add.
Go
I
ahead.
think in unjustified enrichment is when someone benefits unfairly at another's expense without a legal reason. Am I correct?
Yes. Yes, you are. I'm looking at the textbook and it's like, you've got it down. You know exactly what it is. Okay. So we've got other laws in areas in our law. Okay. So they may fall under private or public law or even both. Okay. So they are 4. Yes, there's 4 of them. Mercantile law or commercial law is what? What is mercantile law or commercial law? What do you think it is? Anyone? Anyone want to take a chance?
And please repeat your question.
I want to know what is mercantile law, or another word for it is commercial law. Azande?
Yes, ma'am. Hello.
Hi.
I think commercial law regulates business operation, contract, and commercial transaction.
Yes, it has to do with the company law, insolvency, negotiable instruments, tax law, and so on. Okay.
Thank you.
It is on page 73. Okay. What is labor law? Some of us might have come across this. Yes, Bongani?
I would like to put it as a question that can we conclude that mercantile law is the law that regulates the establishment and the establishment of juristic persons, because we remember that juristic persons, we define them as entities that are created by law for their existence.
Yes, you may. I do agree with you.
Sorry, can Mr. Bongani repeat the statements?
Will it be correct to assume that mercantile law regulates the establishment of juristic persons, the one that we're talking about last time, the legal persons, natural person, juristic person? Can we conclude that mercantile law is responsible for the establishment and regulation or regulating of juristic persons?
I stand with you, my brother.
Yes, most definitely, yes.
Yes, definitely. Good summary of it. Okay, so the labor law. somewhere along the line, some of us must have crossed the word labor law. So what do you think is labor law? Labor law. What does it have to do with? Rhonda? Rhonda, you've got a question?
Sorry, I didn't put my mic on. I was saying labor law has got something to do with the relationship at work between the employer and the employee, like how many hours to work, the contracts to sign, what sort and what not.
Okay, something else we must say when we say that is it can become private and public law. Okay.
Oh, after that, okay. Thank you.
Pleasure. Azande?
Yes, ma'am. Labor law governs employment relationship rights and disputes.
Yes, you're correct. Bongani?
Sorry, I didn't lower my hand from the previous recognition that you gave to me.
Okay. JC Banda. JC Banda.
Evening, ma'am. How are you?
Fine, and you?
I'm good, thank you. Is it necessary for us to actually read answers from the textbook, or we should use other external sources?
I want you to tell me your definition. I have the textbook in front of me, but,
Okay.
and I've got key summaries, but I want to know if you can explain it like you would explain it to your exam. How would you explain it?
Okay.
What is your understanding?
Okay, I think my understanding about labor law is you being treated unfairly. Yeah, this is what I think. Probably for now, you being treated unfairly, or you're not happy with the contract that you signed, perhaps at work. That's how I think. That's what I think about labor law.
Yes, labor law is going to be what governs your interaction with your boss. Your boss is going to give you a contract. If you're not happy, you tell him, okay, but this and this is a problem. If he tells you, okay, but we can maybe change this, the labor law is involved. According to the labor law, you're allowed to do this. You're allowed to work that many hours and so forth. But the labor law can also help you when you and your boss have issues. He's firing you just because you came late one day and he was in a bad mood and he decided to fire you. Then you have a case which is going to be that you have against him, which the labor law is there for, so that you're not treated unfairly. Okay. Does that answer your question?
Yes, ma'am.
Okay, Musa.
Hello, ma'am.
Yes.
I think what I understand about labor law is that is a particular law that deals with the relationship between employer and employees, and it governs the relationship so that there must not be a harm between them.
Definitely. You, Jabulane?
Oh no, it's nothing important, ma'am. I just wanted to caution my brother, the JC Banda. In one of his answers, he just generally said, labor law is when you are treated unfairly. But when he continued, he then clarified that it's when you are treated unfairly by at work. I just wanted to caution him that every time when he answers that question related to labor law, he must include the workplace or the employer, or the relationship between the employer and the employee. It's not only just being about being mistreated. I hope that makes sense.
Thank you, brother.
Most welcome.
Yeah,
sir.
and can I add something?
Yes.
Can I add something? I think Mr. JCV should at least be specific with what he's saying so that the person who be marking can understand that this person has read what he wrote.
Okay. Noted.
Okay. Anyone with another question? Or can I go on to conflict of law? Okay. Conflict of law or private international law has to do with what? Conflict of laws. You can take a guess. What is your understanding under conflict of laws? It has to do with private international law. Leseko. Oh, I'm pronouncing your name wrong. Yes. Azande. Azande, you can speak.
Yes, ma'am. Conflicts of law deals with case in more than one country law, figuring out which country's law apply when there's a dispute with international elements.
Yes. So, for example, if A enters in a contract with B and the case comes before SA court, which law should be followed? If you are from South Africa and you have a contract with someone in Finland or America and the case comes forward in South African court, which law are you going to use? Are you going to use South African law or say American law? That is when conflict. Yes?
I think I might use South African law, but I'm not sure.
We've got I also think South African law because it is in our court. So because it's in our country. If it was the opposite way around, I think you would be the law would be on their side. So this side you will have it has to be solved here. Okay. So I also think Brianna and Escaba, I also think South African law, since disputes are solved in South African court, yes. So it will be according to me, it will also be dealt with in South African courts, not international court. Okay. Both public and private law can become involved, okay, in conflict of laws. Can you... Guys, someone's asking me to repeat the question. I was asking what conflict of laws is, and if you enter into a contract with B, say is from America, but the case comes before SA courts, which law should be followed? So most of us say it should be South African law since it is being resolved here. Okay. What is a legal philosophy? Jurisprudence. Legal philosophy. What law is that? Okay, it says it in the name. It's the law that looks from a philosophical. Ooh, it's late. Azande? Azande, do you have a...
Yes, ma'am. Yes, ma'am. Sorry. Legal philosophy, right?
Yes.
That is law of nature. Oh, sorry, my bad. I didn't hear you correctly, but I'll get back to you.
Okay. Which field of law does legal philosophy look at?
Ma'am, can I answer?
Yes, you may answer.
It looks at the law of the philosophical perspective.
Yes. I couldn't even get my tongue around that now. Okay, so different perspectives. Positivism, natural law approach, feminism. So the philosophical, I'm getting, let me read it carefully. Philosophical evolution of law gives better understanding to law and critical approach acquired. Can be of value to determine the need for legal reform. So you can explain that to me in simple sentences, something easy to remember what legal philosophy is. Seeing that I am having trouble tonight. Yes.
Ma'am, can you say it's a relationship to morality and the role within the society? And its role within the society. So basically what I'm saying is it is the study of fundamental nature of law and its relationship to morality and the role within the society. Can you say that, or am I wrong?
I'm not sure. Do any one of you have a different way of seeing it? I know legal philosophy is how it's going to affect you. I see Esbaba is writing here. It explains how the law should work in effects to society. Study the fundamental principles of science of law. Okay. Bongani, do you have a different answer for her?
Yeah, I do have a different answer in the sense that there were cases here in South Africa where the Muslim marriages, which according to the Muslim law, they are valid even if they are in polygamous nature. But there was a case of, I think it was within a succession, or the marriage was deemed invalid just because the law, the common law by then, that was pre-democracy, the common law by then didn't recognize polygamous marriages as valid before the law. So the legal philosophy is the I think it can be seen as the way in which laws are drafted and interpreted to serve a certain purpose in the society. Giving example that the according to the Muslim philosophy, marriages can be polygamous and valid, while the common law by then regulated that marriages have to be monogamous to be valid before the law.
Okay, Jabulani, you want to add something?
Yes, but I have a follow-up question on Mr. Bongani's answer.
Okay.
I want to understand how does the marriages and all that, as he says, links up with the legal philosophy.
Bongani, can you explain
Yeah.
it to us?
I'm trying to peruse my notes here and find that because the under legal philosophy, I read about the Muslim philosophy. There was a communism which regulates which give rise to the law in China and Russia, North Korea, and we have got. But this is what I found under let me see, under legal philosophy, that the way in which the laws are promulgated, they need to serve a certain mind or a certain agenda within the society. Be it, I will stick to the Muslim. We can stick to the Muslim philosophy or the socialist philosophy, which regulates the laws in Russia, in the communist states. So those laws are developed to serve a certain or a specific agenda within the society. So I gave you examples that under Muslim marriages, polygamous marriages are valid and recognized by their law. But the common law by then, I'll try to check which case was this, where that the court didn't recognize that marriage as a valid marriage to enable a form of succession. I think that was in question. So from my understanding, that the legal philosophy of the Muslims recognize polygamous marriages as valid and not any form of immorality if someone is marrying more than one wife. While the common law by then stipulated on monogamous marriages to be valid. I think it's a case of Ismail versus Ismailin. It's a case of Ismail versus Ismail.
Okay. All right. I think we're going to end it off there. Is there anyone with a question that we can quickly answer before we go? Rhonda, you had a question. Okay, Jabulani, ask yours because...
Oh, yes, ma'am. I feel like Mr. Bongani is confusing his answer, because what he shared initially was correct, but now when he includes the development, I mean the common law and the development of laws in the traditional societies, I feel like he's just confusing himself, because if we look at the definition that we are given in the study guide, it says jurisprudence is the field of law which looks at the law from a philosophical perspective. And then it continues to say legal philosophers ask questions like, what is law? What is the function of law? And what should the functions of law be? In essence, what I understand this to be, we are basically looking at the nature, or the purpose and the principles of law, not entailing the society side of law, or the core of.
You have a valid point. Bongani, do you want to counter?
No, I am not countering. Is learning through trial and
Intellectual
error.
study of law. Yeah.
So maybe my interpretation was the one that was wrong, because I viewed my understanding is that the Muslim philosophy in this case views polygamous marriages as valid marriages before the law. So for me to say common law, I'm failing to because this was pre-1994. I cannot say democratic or as to the constitution. So that's why I say it was a common law judgment that objected to the validity of the Muslim polygamous marriages. But I understand your point, and I'm happy to be corrected, and no qualms.
Not at all, not at all, sir.
Okay. Let's go. Next question. I'm gonna
Ma'am, can I
say
ask?
yes, you can.
Ma'am, is it true that a phone call, if like you're arrested and then you make a phone call, are the phone calls recorded and used against you in the court of law?
No.
Okay, thank you.
No, that is a right you have. It can't be used against you, because then they are attacking your rights that you have. Okay.
Thank you.
Phila? Phila Lombambo. Did I pronounce that correct? I hope so. I see your hands up.
Yes, ma'am. My hand was up, ma'am. Sorry, man. The question I'm asking is not related to the class. I wanted to ask about the class. As you can see, I joined late. I was busy with my assignment. I wanted to ask if there's going to be a revision session for the unit. And then I wanted to ask about the assignment that I was doing, SCL 1501. I wanted to confirm about the declaration form, because do I necessarily have to print it and sign it and then scan it again to submit it with the assignment, or how do I literally go with it?
Yeah, you have to print it, sign it, and rescan it.
Oh. So if I have the assignment and then I don't have the declaration form, meaning the assignment is not valid, ne?
Yeah, they won't really look at it. You have to have your declaration there.
Okay, hey, yeah, and then it's closing tomorrow at 5, meaning I'll have to do it in the morning.
Yeah, otherwise you
I
must.
think I can. Can I say something?
Yes. Musa, you wanted to ask?
Can you hear me?
Yes.
Yeah, I think I can assist. I think I can assist. Can you hear me?
Yeah,
yes, sir.
I think.
Oh, okay. What you use is the app of Adobe Cropped. That's where you can have a declaration form and you can fill it there.
You said an app of what? So that I can download it quickly.
It's
the Adobe
Reader. Acrobat. Yeah, Adobe Acrobat Reader.
Okay, I do have the app. Maybe let me try and open it there. And then what do I do? Do I edit it or what?
You just enter inside the declaration form. Then after that, you will see something like a drop of water at the top.
Okay, yes.
You press it, and after that, you edit the document, you sign it by step. It will show you the T of typing, of writing, and all those kind of things.
Thank you very, very much, Munir. Then how do I attach it to my assignment? Because my assignment is now already saved in PDF as I was typing it with Word, and then I saved it with PDF.
Then after that, you save the document and you have to transfer it to your document.
Do I still use the same? Do I still use the same Adobe Reader to do that?
I'm currently didn't use that, but then I I asked someone to do it. That's someone who at internet cafe because I couldn't do it. But then that's the only way I can help you. I don't know if one of you be able to do it.
All right. Thank you, Menier. Let me try.
Azande, I see you have your hand up.
Oh, ma'am, I wanted to, it's an overhead.
Okay. Rhonda.
Oh, hi guys. Last time someone said for the sake of progress when I asked my question. I don't know, can I ask again my question?
Yes, you may.
Oh, okay. This other lady was saying a law of delict is related to civil law. So my question is civil law related to law of civil procedure, and how is it related to the law of delict? Can someone please explain it to me?
Jabulani.
Can I be given a chance to prepare the answer?
Okay. No, I just thought I saw your hand, so I thought you might know. Okay. I think we should go back to what where is it now? Law of dialect is when something happens and you compensate a injured party. All right. So an injured
Yes.
party has a claim of compensation. So the law of civil procedure is the process or the method how private law disputes should be brought to before court. Okay, Musa, do you have another answer for me or do you have a question?
Hello, ma'am.
Yes.
It's not a question. I just want to add something based on what we were talking about.
Okay.
I think it's a legal philosophy.
Okay.
Yeah, I want you guys to check on page 61 of study guide.
Yes.
On the point of philosophy. Can you see that? Yeah, and it says that the philosophy legal is a system of belief or ideology on which a particular legal system is based on, right?
Yes.
Then there comes the legal philosophy here, and this is a field of which looks at law from philosophical perspective. So according to me, am I wrong if I say that is a system of belief?
It is a system of beliefs and ideology. So yes, that is a explanation of it. Guys, it's on page 61, the second paragraph or the second point in that on that page. It's okay. Rhonda, we were still busy with you.
Okay, I was.
Okay. So, law of civil procedures, the process or method how private law disputes should be brought before court. Okay. But it is different from law of dialect. It's not the same thing.
But they said it's related.
Can I go in since I was the one who said that. I was talking about civil law and the law of delict. I said that they somehow have a relationship.
Okay, ma'am. And then I asked, what does civil law contains?
Remember that civil law are somehow rules that apply when there are arguments between individuals and organizations, especially those who are seeking compensation or resolutions for their.
Okay. Okay.
Yeah.
Also, they are related.
They somehow have a relationship according to my understanding.
Okay, all right. I also
Yeah.
didn't know the correct definition of civil law.
Yeah, it's somehow the same as law of delict, but there's a little tiny bit different somewhere around.
Okay, all right.
Yeah.
Thank you.
Azande?
To ask a lady that's ask what civil law contains. Civil laws covers a broad range of areas, including contracts, which deal with agreement between parties, property law, governing ownership and rights, family laws, handling relationships and obligation within families, addressing wrongful acts causing harm and obligation, outlining duties and responsibilities. Those areas form the core of civil law.
Bongani? Bongani, do you have a question or something?
Yeah, it's something that I think is important to be considered here. That the civil law as we know it is emanating from the 12 tables of the Roman law. So how those laws were designed to regulate the relationship between the citizens, all those laws from the 12 tables make the backbone of the all the civil laws.
Jabulani?
Yes, ma'am. While we're at that, I still have a question for Mr. Bongani and Azande on the answer they gave me previously on the question I had.
Okay.
I don't know if they still remember my question though.
I don't think so.
Okay, I wanted to know which law is responsible for the rules that are targeted to the investigators during the evidence gathering.
Bongani? Azande?
My answer was that this has to fall under procedure law. Either it's a criminal procedure or it's a civil procedure. Let's look at an example for a civil procedure.
Bongani, we can't hear you.
We first institute a letter of demand. That's a procedure, regardless of the, as long as the procedure is to be done lawfully. This is what the procedure states. Looking into criminal law, we say the presumption of the criminal law is that it assumes that the accused person is regarded innocent and is proven guilty beyond reasonable doubt. So the investigations that are done satisfies the requirements of this procedure that the accused person is innocent, and it is the prerogative of the investigative officer, the prosecutor, to prove beyond reasonable doubt that in fact this person is guilty as charged, not innocent as it is assumed.
So what is your answer, Mr. Bongani? Because now you are giving me two answers. You are giving me civil law and criminal law. Initially, you said it's civil law.
The civil procedure. The civil
You are
procedure.
standing by civil procedure.
I gave an example of instituting a letter of demand to fulfill the requirements of a civil procedure towards making a claim of money. We're looking into the criminal procedure. What does the criminal procedure say? It says anyone who is accused of a crime is innocent before the court, and that person has to be proved to be guilty. So whoever is doing the investigation is satisfying the requirement to prove beyond reasonable doubt the guilty part, because the law assumes the person is innocent. So if the person is making an investigation, from my understanding, he is fulfilling the requirement of proving beyond reasonable doubt. We are not looking into the contents of the evidence that is being presented, but the act of investigating is to point out the actions or the role or the guilty, which the procedure is not recognizing at this point, because it is giving a window to prove beyond reasonable doubt. I'm not sure if I'm answering you or I'm halfway.
You're actually losing me along your answers because you're making them long, and I lose the point that you're making. I want to make sure, are you still standing by the fact that civil procedure or civil law is the one that determines the rules for the investigation proceedings?
Not necessarily that the not necessarily that they regulate the investigation. From my understanding, either the investigation are done to prove an act of negligence, or they are done to prove that XYZ met at ABC. There is a procedure that governs how the criminal case has to be dealt with.
Yes, we have covered that, and we said it's criminal procedure. My question is,
a criminal procedure action or is a civil procedure action?
It can be. That's wrong. When you in criminal law procedure, you can include civil procedure.
No,
I'm sorry to stop you.
That's why I said a criminal procedure is based on the premise that the accused person is innocent until proven guilty beyond reasonable doubt. And I said if the investigation are done, they are mainly satisfying the requirement of proving beyond reasonable doubt. That's where I stopped. That any form of investigation that is done is trying to satisfy the requirement of proving beyond reasonable doubt that the accused person is not innocent as assumed by the law, but guilty as charged.
Can you please repeat the question? Maybe we could assist you.
Yeah, please, because I'm really lost. Which law is responsible for setting out the rules for the evidence to be gathered? In other words, who sets out the rules that should be followed during the gathering of evidence?
Stefan, can I say something in my view? I think there are certain policies, but not, I cannot say a law, but then I can say maybe it's a policy of a police station, maybe that says that in the police station we operate like this, under police station we follow this policy that we do investigation first, then after that we're going to follow the certain laws to resolve the cases.
I think I don't think it can be correct, because when we go into the world of policies, that's a different thing. Because I feel like a policy can be set by anyone. You can also set a policy that I must get arrested. So with law, it's direct, it's specific, that who and so is obliged, or it's permissible to do X, Y, and Z. So I don't think a policy is the right word to use.
Okay, Azande has
Hello.
yes.
Yes, I think. Sorry. I think during, as you said, during the gathering of evidence. Yes. I think during the gatherings of evidence, the rules of criminal procedure should be followed, especially those related to search and seizures, warrants, and rights of the accused.
Now I can agree with that. Not civil procedure, because to my understanding is that when investigations are done, they are enforced by the state, and civil procedure, this is perfectly, I mean, it has everything to do with the relationship between the private organizations or individuals. So in as far as that is concerned, the investigations under the civil law might or can be done by the litigants. If I do stand to be corrected. But when we include now the investigations are done by in the public world. They are done by the state.
Yeah, maybe the from my understanding, the argument is on the wording, because if from the example that I gave you, that you are to institute a claim is under a small claims court, you institute a letter of demand. But this is what the litigants are doing. I'm proving that ABC owes me money, and I'm writing down all the details how that transaction transpired, and he has to acknowledge that debt by signing.
No, I agree with you in this case.
You see, yeah, yes. Maybe that's why I'm saying maybe we're arguing on the use of terms, but the understanding is the same.
So the final answer would be that both the civil and the criminal law, they are applicable in setting up.
It depends on the matter. From the example that you gave, you spoke about litigants. We come back to the civil procedure, and I'm giving a basic example of instituting a claim through small claims court. There is the procedure to institute a small claim, a letter of demand, detailing everything that you need the other person to pay you back. That's the procedural. And the litigant will sign acknowledging that what the applicant is bringing against me is something that I'm aware of, and I'm honoring that debt. So it is governed by, in this case, by civil procedure.
So it depends with the case.
It's a criminal case. When it is a criminal case, I'm coming back to the presumption that a criminal case is based on the premise that every accused person is innocent until proven guilty beyond reasonable doubt. So if the investigation are done, their main purpose is to prove that the assumed innocent person is in fact guilty of 1, 2, 3, 4 crimes.
Yeah, I agree with Brianna there. You must slow down with your English. You've been explaining this, but now I'm understanding you into the court. Thank you so much, sir.
All right, let's put it like this. Civil procedure, you acknowledge the negligence that you have done. On criminal procedure, the state proves that you are guilty. I'm not sure if I have toned it down my English.
No, I'm answered.
Okay, is there any question or can we say good night? Because I see we like over 2 hours. I know you all, most of us. Yes, Azande.
I'm not saying anything, ma'am.
Okay, so I am going to set the recording. It's going to be a long one. I don't know why it's been doing that whole thing. But yeah, it says 4 hours, but I don't think we were that busy. But in any case, I hope you have a lovely evening, and I will post the video on the group as well as a poll to say when we're going to meet.
There's a hand, ma'am.
Pabelo, is that your old hand? I think it's her old hand. She has trouble putting it down.
Oh, okay, no problem. Thank you so much, ma'am.
Pleasure. Okay, so I'll have a poll on the group again to say when we have meeting again. And Dani, you have a question? Yes.
Yes, yes. I heard Jabulani says he's satisfied with what Mr. Bongani has said, but me, I'm not that satisfied because of.
Oh no.
Jabulani's question was that what law do they rely on when investigators are looking for evidence, such thing like that? But when I look at civil procedure in the book, it looks like it has to do with many processes, not the process of evidence only, but many processes are brought before the court. But if you look at law of evidence, it has to do with only the evidence, on how. A law of evidence regulates what evidence may be collected, how it must be collected, and whether it can be used in court. So I consider you guys should look at the regulations of civil procedure and law of evidence, because civil procedure, it has to do with many processes, not only evidence. But the question of Jabulani, it focuses on the evidence, on how the investigators, the law they rely on when the investigators are looking for evidence. Thank you, ma'am.
I think that was answered because they, to my understanding, he said it depends with the type of case that is being brought forward at that time. So under civil procedure, obviously, it has nothing to do with the investigating officers. This has to do with the litigants and the legal representatives of the individual that would have been inquiring about the case. But in as far as the investigations are conducted in the procedural law, that is those rules are set out by the criminal procedure, if I'm not mistaken.
And someone wrote that I've tried to explain this point so many times, because the component of evidence comes later. from its admissibility, the facts or the admission and confession that forms part of the evidence, or anything that is the real evidence, anything that is brought before the court. Its only purpose is to prove that the accused person is guilty of the crime. Nothing more, nothing less. And the defendant's attorney will bring evidence to prove that this person is innocent. So that's why this has to be beyond reasonable doubt, because everything is being objected by evidence. So without a real question, a real case in question, it will be difficult to make a good understanding or a good definition of my argument. But I stand by my argument that it depends with the case. Either it's a civil matter or criminal matter.
You know, Mr. Bongani, I think the confusion here arises because at first you also gave me a general answer, and hence I had a follow-up question. Now that you expanded on it, it does make sense. What you must be careful of is the word choice that you use, because you might be thinking that you are expressing a certain information in one of the words that you choose. Because in as far as I was asking you my question, I was asking you about the investigations, and you included that under the civil procedure, and it has nothing to do with that, you know. So I think the problem is with the word choice.
No problem. And I said I accept any correction, and I'm happy to be corrected.
No worries, sir. No
Sharp,
worries.
sharp.
Guys, we are tired now. Eish. Oh,
yeah.
I'm sorry. I thought my
Hey,
mic
yo,
is
we are
off.
tired. We are really tired now.
Guys, you're more than welcome
I'm
to leave.
sorry. I thought my mic is off.
Understand the contents of what we are studying. What's the purpose of us meeting here if we'll leave not understanding everything that we are talking
I'm
about?
sorry. I thought my mic was off. I'm sorry, guys.
Bye now.
Okay, is there any questions? Are you all tired now?
We'll
Who's that?
remind you this, Azani. We'll remind you this. When you don't understand something, we'll remind you this remark that you just made right now. Bye, guys.
Bye-bye, guys. We will let you know when the next meeting is. Okay. Then we'll do
Thank you so
Unit
much,
6.
guys. Thank you, ma'am. Bye.
Thank you all.
Bye.
Bye,
Bye.
Leandri.
Bye.
Bye, Bongani.
Bye, everyone. See you on the
A
next
question for
session.
what now?
I'm joking.
You can ask it tomorrow.